The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Hi, I'm Kevin O'Flaherty from O'Flaherty Law. I hope you find this Learn About Law video and podcast helpful. If you need some help, please feel free to give me a call at 630-324-6666. That's 630-324-6666. Thank you so much for watching and listening.
Hi, this is Andrew with Learn About Law, and in today's video we'll review the different adoption choices available under the Illinois Adoption Act. So first we're going to talk about related adoptions. So one or both of the adoptive parents are already related to the child. One of the most common types of related adoptions is a step-parent adoption. In this scenario, both the parent and the step-parent must petition the new spouse of the biological parent and becomes the legal parent of the child. This type of adoption should be straightforward, but there are a number of issues that commonly arise, so it's best to have legal help going into the process. Second, we've got adult adoptions. These involve the petitioners legally adopting a child over the age of 18. The adult child must consent to his or her own adoption. The biological parents of the adult child will not receive legal notification because their consent is not required. If the petitioning parents are not related to the adult child, then he or she must have lived with the petitioning parents for a minimum of 2 years. Third is going to be agency adoption. The biological parents surrender their legal parental rights to a child welfare agency, which then places the child with the adoptive parents, already screened by the agency and eligible as pre-adoptive foster parents. There are two types of agency adoption processes, and determining the right one for you is a good conversation to have with a qualified adoption attorney. Fourth is private adoption, which involves the biological parents placing their child for adoption directly with the non-related adoptive parents. In this type of adoption, there is no adoption agency involved, and the attorney will bear the brunt of the work. The attorney will be the main means of communication between the adoptive and biological parents. Fifth is going to be inter-country adoption. So as the name implies, inter-country adoption is the legal process by which a child born in a foreign country becomes the legal child of U.S. parents. The adoptive parents must comply with the adoption laws of the child's country of origin, the United States and the state of Illinois. A home study must be done by a licensed child welfare agency, and the adoptive parents must be approved before the adoption process can begin. The intercountry adoption process can be lengthy and involves a number of legal milestones. However, with the help and guidance from an adoption agency and a good adoption attorney, the process should proceed smoothly. Six is a DCFS adoption. Children whose biological parents and their parental rights terminated under the Juvenile Court Act of 1987 become available for adoption. Often these children have been abused, neglected, or exposed to drugs on a regular basis. The court handles appointing a guardian with the power to consent to an adoption. The guardian can be a private person, but in most cases is the DCFS guardianship administrator. If the other person is petitioning for a DCFS adoption, the guardian must consent to the adoption or refuse under the grounds that they intend to legally adopt a child. The attorney will collect all the necessary documentation for the adoption process. A DCFS adoption usually moves quickly as the child is already living in foster care. 7 is a co-parent adoption, also known as second parent adoption. This is when two unmarried individuals become the legal parents of a child. In a large majority of cases, one of the petitioners is already the parent or related to the child. Parties in a civil union will be treated as a married couple. Not all counties in Illinois will authorize a co-parent adoption, and those interested in this adoption option should strongly consider filing in the Cook County Court. If one petitioner is already related to the child, then the adoption will proceed normally as a related adoption. Number 8 is going to be a standby adoption. When the current biological parent of a child allows the future adoption of the child contingent on a future event such as death, illness, or some other event specified. This is a type of adoption is often seen in elderly patients or terminally ill patients with an underage child. Lastly, we have interstate adoption. These are adoptions when the adoptive parent lives in a different state from the child. These adoptions follow the Interstate Compact on Placement of Children Act in an effort to enact uniform procedures across the U.S. and to place a child in the best situation. This act also exists to regulate the state-to-state movement of adopted children and to decrease the occurrence of child trafficking. Interstate adoptions can be cumbersome, and if both states have adoption agencies involved in the process, it will pose fewer problems. Adoptive parents should seek the guidance of a qualified adoption attorney, depending on their situation, as some states prohibit private adoption across state lines. Every adoption situation is unique, and navigating the often complex process of adoption can be difficult without proper guidance. Whether you're working with an adoption agency or not, having a knowledgeable and competent adoption attorney is key to a smooth process. As always, thanks for tuning in.
Hi, this is Kevin O'Flaherty again from O'Flaherty Law. Just want to let you know we offer free consultations in many areas of law, and we have several geographic locations for your convenience. So if you need some help, please feel free to give us a call at 630-324-6666. That's 630-324-6666. And thank you again for watching and listening.